Welcome. My name is David Hoffman from Duke's Sanford School of Public Policy, and it is my pleasure to host this webinar. We have the world's top experts with us to explore options for a U.S. comprehensive federal privacy law, so we will not do lengthy introductions. Instead, you'll find in the chat area a website URL that will take you to the detailed bios of the speakers and links to the research the Duke team has done on these topics. It is our intent to add to the website over the next year. We intend for the website to be a resource for public policy stakeholders as Congress drafts a law. Please send us comments and recommendations for additions. I want to express my deep gratitude to the student researchers for all of their work on this project, and their names are listed on the website. I would also like to thank our co-sponsors, the Duke Keenan Institute of Ethics, the Duke Science and Society Initiative, and the Duke Program in American Grant Strategy. Also, the panelists will respond to questions at the end of the program. Please type your questions into the Q&A area, and one of our lead researchers will select questions for the panelists. And now I'd like to kick off the program by inviting Dean Kelly to say a few words.
Thank you so much, David. And thanks for your leadership that you have provided to Sanford and Duke in this area of technology policy. And at the Sanford School, we're really focused on our research on teaching and practical public policy problems to solve the problems that are pressing on people's lives, and especially how they're intersecting with a democracy, which is an area, of course, that today's topic intersects heavily with. We want people to be able to trust technology. It's such a critical component of our mission at the Sanford School, and I'm thrilled to have the FTC Commissioner, Christine Wilson, and this exceptional group of people, experts here to discuss how government can promote that trust. Welcome to everybody in our audience. We're excited to draw you into a conversation about how we can put in place a privacy law that will optimize both the innovative and the ethical use of data. In Sanford, we have created a special concentration in technology policy in our Masters in Public Policy program. And we've also integrated into our undergraduate curriculum and privacy, cybersecurity, data governance questions are specific areas of much of the research that goes on at Sanford. How governments can hold companies accountable for responsible data governance and robust cybersecurity, and how these companies can demonstrate whether they have put in place the people, the policies, and the processes to be responsible is a really important research question that we will continue to focus on, but not just focus on describing the problem, but just like today, thinking about solutions. So thank you again all for joining us at this webinar. I hope you reach out to David or me after the program and to learn how you can participate in the many exciting things we have underway at Sanford to help develop the next generation of leaders in technology policy and to spur ideas for solutions to these important problems. David, back to you.
Thank you, Dean Kelly. And now I would like to call upon Dan Caprio to introduce Commissioner Wilson.
Thank you, David, and thank you, Dean Kelly. I'm Dan Caprio, co-founder of the Providence Group. It's my pleasure to introduce my good friend, Christine Wilson, for tonight's event here at Duke, which is fitting since we were here virtually 8 months ago celebrating Data Privacy Day with David, Jolyn Dellinger, and Cam Carey. Commissioner Wilson is an inspiring public servant and a tireless advocate for the work of the Federal Trade Commission protecting U.S. consumers. Commissioner Wilson was sworn in 3 years ago as a commissioner of the FTC, having previously served at the FTC as Chairman Tim Meares' chief of staff during the George W. Bush administration. Commissioner Wilson has practiced competition and consumer protection law, both at law firms and as in-house counsel, serving as senior vice president for Delta Airlines. Prior to joining Delta, Commissioner Wilson was a member of the Washington, D.C. antitrust practice groups of Kirkland and Ellis and O'Melveny and Myers. Commissioner Wilson, the floor is yours.
Dan, many thanks for your kind introduction. It is fitting that Dan is the person to introduce me. He is the person who introduced me to Professor David Hoffman, and so he indirectly helped to launch this project. Many thanks also to Dean Kelly and Professor Hoffman and to the Duke University Sanford School of Public Policy for hosting this event. I've known Dean Kelly now for about 10 minutes, and I find her enthusiasm for this project and for work in this area incredibly infectious and engaging, and so I'm an immediate fan. Thank you, Dean Kelly, for your interest. So this evening's proceedings are the culmination of a months-long project. My office and I have worked closely with Professor Hoffman and students both at the Duke University Law School and the Sanford School of Public Policy. I'd like to give special thanks to my attorney advisor, Bobby Spector, who spearheaded this project for my office. I have been so excited about this project. Bobby's updates were always the highlight of my workday. We launched this project because preemption and private rights of action were identified as key impasses on the road to federal privacy legislation. Our goal was to identify and examine different approaches that Congress has employed in other legislation, including but not limited to privacy laws. Our student researchers analyzed the preemption provisions in 10 US statutes and the GDPR, and private right of action and remedy provisions in 6 US statutes and the GDPR. Their scope of research encompassed not only the statutes, but also relevant case law, law review articles, and other scholarship. Duke has made the results of this comprehensive research publicly available on a Duke-hosted website to serve as a resource for legislators, privacy professionals, and scholars. We hope this compilation will demonstrate that preemption and private rights of action can be addressed constructively in federal privacy legislation. I want to thank the students at Duke and my law clerk, Lizzie Americo, for their excellent work on this project. I also want to thank the many academics and policy folks who contributed their time and effort to this project. Many of them are featured on our panels this evening, so I know it's going to be a fantastic discussion, and I'm really looking forward to it. Before going further, I must add the traditional disclaimer that the remarks I deliver today are my own and do not necessarily reflect the views of the commissioner or any other commissioner. With that out of the way, let me give you some context for this project. During my tenure as a commissioner, I have advocated repeatedly for federal privacy legislation. I am a strong believer in free markets and deregulation, so this advocacy has come as a surprise to some observers. But I didn't arrive at this conclusion lightly. I talked with a variety of stakeholders, and I read case law, empirical studies, articles, sector-specific privacy legislation, legislative drafts, including David's when he was at Intel, books, and news reports. And ultimately, I concluded that significant information asymmetries exist between consumers and the entities that collect, monetize, and share consumer data. These asymmetries create a market failure. Consumers do not fully understand how their data is collected and used, and without this information, they can't analyze accurately the costs and benefits of using different products and services. The risks to consumers from the unchecked collection of their data have intensified. Gaps in existing sectoral laws have created inconsistent protections that continue to widen. Healthcare is a great example. Information collected in traditional medical settings is protected by HIPAA, but information collected through websites, apps, or wearables is not. As we all know, the COVID-19 pandemic has exacerbated this issue. And the concern extends beyond consumer privacy, going to some of the democracy issues that Dean Kelly talked about. Certain uses of consumer data have serious implications for civil liberties, including our Fourth Amendment protections. These concerns also intensified during the pandemic. My concerns begin but do not end with individuals. Federal privacy legislation is necessary to give businesses guidance on the rules of the road. The need is more pronounced as additional states pass privacy legislation. Complying with myriad and potentially conflicting state laws is costly at best. At worst, it's impossible. The bottom line is that federal privacy legislation is long overdue, but two key gating issues must be resolved before it becomes a reality. And that stubborn fact brings us to the topic at hand, avenues to address preemption and private rights of action. And so I'll briefly touch on those two topics. First, preemption. Previously, I've said that preemption is necessary. Businesses need the predictability of a federal standard. Moreover, the growing patchwork of state laws will impose costs and erect barriers to entry that ultimately will harm consumers and competition. I am a strong believer in federalism and the benefits of having states serve as laboratories of democracy, but there are some areas where a federal interest takes precedence. The research the students amassed on preemption revealed many interesting findings. I'll highlight just a few. First, federal statutes that preempt an entire field are actually rare. It's more common for statutes to establish a federal floor and allow states to pass more stringent laws. In other words, the federal law creates a minimum standard. HIPAA and the Clean Water Act are examples. Other statutes employ conflict preemption. The federal and state laws coexist, but if a conflict arises, the federal law prevails. The Civil Rights Act takes this approach. Second, even scholars who do not support preemption acknowledge there are circumstances under which federal consolidation has benefits. For example, Paul Schwartz, in an article arguing against preemption in federal privacy legislation, explains that preemption facilitates the avoidance of inconsistent regulations in certain circumstances, including through the establishment of what he calls field definitions that can lower compliance costs. Another scholar, Patricia Bellia, noted that if a federal privacy law establishes only a baseline standard that allows states to promulgate more robust regulations, the most stringent state law will become the de facto federal standard, e.g. the CCPA. So Professor Bellia writes that preemption may be necessary to displace a law that has national consequences but has not been subject to the national political process. Back to the democracy point. This point resonates with me. I've said repeatedly that elected members of Congress are best situated to make the policy decisions and value judgments needed to promulgate national privacy standards. Professor Bellia also argues that a federal law that establishes carefully crafted minimum privacy standards that apply across sectors, but that permits states to fill gaps, may be a plausible solution. And I think this approach merits discussion. Professor Schwartz argues, however, that full field preemption carries a risk that a statute eventually may become ossified. And this concern is valid given the rapidly evolving privacy landscape. A law written today can only address the practices and harms that we know about today. For this reason, I support vesting the FTC with carefully tailored APA rulemaking authority to facilitate updating key definitions and provisions. COPPA provides a good model here. But I'll be the first to admit that rulemaking is not always efficient. Another option would be to include in the legislation sunset provisions or other opportunities for reevaluation, as panelist Cam Carey has proposed. And the GDPR experience is also instructive. In June 2020, the European Commission published a report on the application of GDPR. One aspect examines examples of fragmentation across member states, including age limits for when children may provide consent and protections around the processing and sharing of health and research information. In these areas, the Commission noted that divergent policies created difficulties for businesses working across borders. Now, consumer privacy, particularly online, is far more complex and nuanced than the subject area in some of the sector-specific statutes that we researched. Online privacy issues affect virtually every business that has an internet presence, and the very nature of the internet makes it likely, again, that the most stringent state standard will become the de facto national standard. Some stakeholders may prefer this outcome because they believe the state standard is optimal. Preemption may succeed, though, if the federal standards created for businesses, in conjunction with the rights and remedies established for individuals, are robust. As a practical matter, businesses have a significant influence on the debate, and frankly, they are unlikely to support legislation that doesn't include preemption. Conversely, consumer advocates currently don't support preemption. Also, it's not likely feasible for a federal privacy law to cover the entire landscape. Existing state and federal laws provide important privacy protections, and new legislation will need to acknowledge and accommodate this reality. In approaching this project, we determined that our primary focus should not be how to satisfy all relevant stakeholders. Instead, it should be ascertaining the best policy for consumers and competition. And so we asked, how can we craft a law that provides individuals with privacy protections, reduces information asymmetries, and provides consistent standards for business that maintain competition and incentives for innovation? Actually sounds like a pretty tall order when I say that out loud. So we believe the starting point is to isolate the goals and primary regulatory objectives of privacy legislation. I believe the goal of federal privacy legislation is to create baseline privacy rights for consumers and consistent standards for business. Legislation that simply provides a floor and allows states to enact more stringent laws may establish baseline rights, but it will not create consistent standards for businesses. And in my view, this is suboptimal. If the law provides strong rights and imposes appropriate standards and obligations on businesses, as well as robust and accessible remedies, more stringent state laws shouldn't be necessary. And this conclusion leads to our second topic, remedies and private rights of action. To start, we sought to analyze the goals of those who advocate for a private right of action. One frequently stated rationale points to under-resourced enforcement agencies like the FTC and concludes private rights of action are necessary to provide incremental deterrence for businesses and remedies for consumers. Of course, a strong privacy law that includes sufficient funding could obviate this need. As you may have seen, the Energy and Commerce Committee of the U.S. House of Representatives last week proposed $1 billion for the FTC to create a new bureau to address privacy and data security. This investment would put the FTC on more equal footing with foreign DPAs. And ideally, this appropriation would be tied to privacy legislation that establishes boundaries for the work of the new bureau. Returning to private rights of action, studies have shown that abusive class action practices increase costs for businesses, while frankly providing little in the way of redress for consumers or changed business practices and deterrence. Even giving class actions the benefit of the doubt, the research the students conducted led me to conclude we actually need a broader conversation. Specifically, the discussion should not be limited to whether federal privacy legislation should have a private right of action, but instead should focus on establishing a constructive remedial framework. Legislators should consider the policy goals of the regulatory regime, how best to accomplish those goals, and how best to create appropriate deterrence. This analysis is drawn from a compelling article by panelist Chris Hoofnagel and others titled "Breaking the Privacy Gridlock, a Broader Look at Remedies." The authors created a matrix, a set of questions that we believe regulators could use to map remedies for privacy. Their analysis highlights 3 key points. First, remedies should be tied to policy goals. Second, no one remedy can successfully promote even a simple goal, and therefore an effective law should include multiple remedies. And third, intermediaries and third parties play a powerful role. Using this article's framework, our student researchers analyzed numerous statutes, and that analysis is also included in the website. Rory Van Loo, another panelist, has written about additional remedial avenues beyond private rights of action. These possibilities include enforcement through a supervisory authority and through third-party intermediaries, which may better serve the policy goals of privacy legislation than class actions. When viewing remedies through this broader lens, it becomes clear that an all-or-nothing approach will not serve the goals of privacy legislation. Cam Carey has proposed privacy legislation that envisions a private right of action in limited circumstances and includes substantive and procedural limits. And I should note that Cam's work that he rolled out last summer was actually instrumental in planting the seed in my mind for figuring out how to reach constructive solutions with respect to these 2 gating issues. And so I owe Cam a big thank you. Others have also proposed nuanced approaches, such as a private right of action for specific highly sensitive types of data or only for injunctive relief. Ideally, the remedies in privacy legislation will turn on the injuries suffered. I believe there are significant cognizable harms that result from online privacy practices. The Supreme Court's recent decision in TransUnion, which our remedies panel will discuss, may have drastically changed the landscape. Even if Congress were to pass legislation creating a right and providing a remedy, would it survive the standing test in TransUnion? In my view, this development highlights the importance of carefully considering other remedies and enforcement mechanisms in federal privacy legislation. As I hope my remarks have illustrated, these issues are complex and fascinating, and the research that we have collected is robust. I hope our compendium will serve as a useful resource for regulators, scholars, and others. Following this event, I'll be writing an article with Professor Hoffman and Bobby Spector, my attorney advisor, that delves further into the research and also draws on the conversation that our panelists will be having this evening. And so I'm really excited to hear what our panelists have to say. So in closing, let me reiterate my thanks to Duke University and all of the students who worked so hard on this project. And also I'd like to thank our panelists for what I know will be an interesting and engaging discussion. Thanks.
Commissioner Wilson, thank you so much for those remarks, and thank you for your continued leadership in this area and your support for the work on this project. I would now, speaking of the work on this project, like to call on one of our lead student researchers to introduce the first panel. Alexis?
Hi, everyone. I had the pleasure of working with Professor Jolynn Dellinger for the past few months, and I am very excited to introduce her tonight. She works in the area of ethical tech and teaches privacy and ethics at the Kenan Institute of Ethics, Duke Law, and UNC School of Law. I could give a much longer introduction, but I'll just go ahead and turn it over to her now.
Oh, thank you so much, Alexa. And also thank you to Mark. I just have to reiterate the thanks to the students who have done the amazing work on this project. And also a big thank you to David Hoffman for his vision and putting this together, and to he and Bobby for making it happen. I'm going to refer you to our webpage for more extensive bios, but I wanted to take the chance now to quickly introduce you to our amazing panelists. We will be featuring in our discussion of preemption, Stacey Gray, Senior Counsel at the Future of Privacy Forum, Cam Carey with the Brookings Institution and former Acting Secretary of the Department of Commerce in the Obama administration, as well as Jessica Rich, former Director of the FTC's Bureau of Consumer Protection and with the FTC for 26 years, and now at Kelley Drye. If you all could join me, that would be great here on the panel. Terrific. So this panel is dedicated to the issue of preemption. Generally speaking, the extent to which a federal law may preclude state law on a given topic or in a field. And preemption, as noted, has been a fairly polarizing subject, and potentially a barrier to the progress in the pursuit of a comprehensive federal privacy law. So we hope to shed some light tonight on options that can help us move forward. As we get started, I just want to note that most of the proposals for privacy legislation that we've seen so far, including the Consumer Online Privacy Rights Act and the Consumer Safe Data Act, seem to carve out existing federal laws. So effectively leaving our health privacy law, our student privacy law, GLB for Graham Leach Bliley and finance, the Fair Credit Reporting Act, for example, as is. And so before we dive into the weeds on preemption, Stacey, I'm hoping that you could be able to briefly set the stage for our conversation and the scope of that conversation, explaining how these carve-outs affect the preemption issue that we're talking about tonight.
Absolutely. Thanks so much, Jolynn. And I'm happy to participate and kick us off. So Future Privacy Forum has been doing a good bit of research on this issue. And just to start us off, I would say that federal preemption is a core inevitable question that stems from the fact that we have a system of dual sovereignty between the states and the federal government. And so even if a federal law doesn't ever use the word preemption, preemption is still going to be at work. And so this is why it's very helpful, Jolynn, like you said, to start off with a couple of points that we can agree on. So 3 very quick things. First, state governments in general have much broader authority to regulate, especially over some purely local issues like state records, law enforcement, public education, that the federal government might not have the ability to change. But there's no question that Congress does have the authority to regulate information privacy broadly under its power to regulate interstate commerce. This is particularly true the more that we define personal information broadly to include things like device identifiers. Second, federal law will always supersede state law where there's a direct conflict. So this is why I say even if a federal law doesn't use the word preemption, right, it's still there. If there's a direct conflict and it's impossible to comply with both federal and state law at once, federal law wins the day under the Supremacy Clause. But in every other situation, Congress can preempt state law to whatever extent it deems appropriate or necessary, all the way from choosing not to preempt at all to field preemption, as Commissioner Wilson pointed out. And finally, to your main point, Jolynn, preemption is primarily a question of how federal privacy law affects states. So for this conversation, we're really talking about how a federal omnibus privacy law is going to affect the California Consumer Privacy Act, the Virginia Consumer Data Protection Act, the new Colorado Privacy Act, right? Not only that, but the hundreds of other existing state privacy adjacent laws and the common law and every law that might be passed in the future, right? It is a totally separate question from how federal privacy law will interact with other federal laws. So we have approximately 12 other federal sectoral privacy laws that govern privacy in healthcare, banking, credit reporting, surveillance, or that govern a particular business activity, such as collecting data from a particular group, like our children's privacy law that has to do with collecting data from children under the age of 13. And just to add complexity, each of those other federal sectoral privacy laws approaches preemption itself differently, right? So some federal laws, for example, the federal law governing commercial email, that law is very preemptive. States do not govern commercial email, generally speaking. But our federal privacy law governing commercial phone calls and robocalling, the TCPA, is not preemptive. It sets a floor and states have great variability in how they approach that same subject. So the first question that we would address to policymakers in deciding preemption questions under an omnibus privacy law that fills in those gaps is if the decision is made to not supersede or to leave in place other federal sectoral privacy laws, it also makes sense to leave in place the state laws that complement those federal sectoral privacy laws, right? Because these are entrenched silos or existing regimes. It wouldn't make sense to wipe out state healthcare laws if we're not also making changes to HIPAA. So 3 points I think we can all agree on to set the stage on what we're talking about, and I'll give it back to you.
Perfect. Thank you so much for that introduction. And then I think we just need to jump right in because this is a polarizing topic. And so Jessica, I'm just going to ask you why? Why is this such a lightning rod when it comes to federal legislation? Why is this such a problem? And would you characterize this decision about preemption as a political choice?
So now well, first thing I'll say is I'm delighted to be here with such a great group. So, I'll jump in. So we're zooming out now and talking really big picture. So yes, the issue draws a strong response because the stakes are high and because the debate has been going on so long, positions have hardened. Cam and I have been involved in this debate for over 20 years. So this is fun. On the anti-preemption side, and some of this has been touched on by people who've already spoken, you know, the states have stepped up to protect privacy when Congress hasn't, despite debating these issues for 20 years. Now we're going to preempt the states. I mean, that's a lot of the reaction people have. There's a fear that the federal standard will be weaker than the state protections it's preempting, leading to weaker privacy for everybody. Some state laws, and this gets into what Stacey was talking about, have coexisted with federal sectoral laws for years. Why should we preempt those? And wouldn't it be more disruptive to do that, then leave those in place. And then the law being contemplated here would span the entire economy. This is much higher stakes and broader application of preemption than just preempting in the context of sectoral legislation. Now, on the pro-preemption side, having one national standard makes sense for some of the reasons that the commissioner stated. The economy and the internet cross borders, people cross borders, shouldn't there be consistent protections nationwide? For companies, complying with multiple disparate standards is highly burdensome. Now, the state laws passed so far aren't that different, and but lots of proposals have been really different, and so that's not necessarily going to stay that way. For consumers, this is something people also miss. You know, when I was at the FTC, you do consumer education, and we were never able to educate consumers on what their rights in privacy were, because they didn't have very many. But that same problem applies when you have multiple standards. So much of what a law does is also tell consumers what their rights are. And when there are multiple standards, it's very hard to make consumers vigilant about violations that may be happening because they don't know what standard applies. And then finally, one standard makes sense as the US deals with different companies and tries to mop up after all these Schrems decisions that are leaving a mess all over the place. So that's the argument on the other side. And as to whether this is political, this seems like a language issue, and that's Cam. I'm going to turn it over to Cam, but I'll just say it is a matter of courage, leadership, and compromise by Congress, and also having a clear sense of what your goals are in passing any federal law. I'll toss it over to Cam for the political discussion.
Thanks, Jessica. I'll certainly jump in on that. And I do want to thank David Hoffman and the Duke student team and Commissioner Wilson and our office for the really terrific work that they've done to illuminate the nuances of the issues that we're talking about here this evening. And I'm going to say, I feel sort of very validated by Christine Wilson's remarks. I mean, not only the very kind things she had to say about the report that we did at the Brookings Institution last year, which tried to illustrate ways of bridging the gaps on these issues between the key Republican and Democratic bills. But more particularly, I think just by the thought process that she's gone through to look at the many nuances of these issues and the ways that all of these integrate. And I think that's very much part of my response to this question. Preemption as the research that the Duke team and the FTC have done, the great work that Stacey Gray and Future Privacy Forum have done on this topic, really show this is not a binary choice. Christine Wilson talked about the fact that field preemption is really the exception in most preemptive federal laws, and yet field preemption is what's been offered by some business groups and in Republican bills. And correspondingly, the Democratic bills mostly would leave, at most, sort of make federal legislation a floor. And for a lot of the reasons we've talked about, there's a lot of ground in between. There's really a spectrum of ways to deal with these issues. And where you come out on that spectrum is fundamentally a political choice. The reality is that each party in Congress and the consumer and the business interests that they are dealing with has veto power over the other. Comprehensive privacy legislation is not going to pass with field preemption. It is not going to pass, without significantly limiting some of the role of the states in establishing a broadly consistent federal standard. So that's where you really get to political choices and having to sort of pick and choose from some of the in-between ground. I happen to think from my background as in communications law before joining the government, that issue preemption, conflict preemption works pretty well. But at the end of the day, these are compromises that have to be worked out in combination with other elements of the debate to make this a win-win situation. And I think that can happen here.
Okay, so we have a very binary feeling when we're talking about Democrats and Republicans. But what we're saying is, when we're doing this legislation, we can't be binary about it. We gotta act like we're on the same team. Yeah. Legislation, we've all got to participate, and we've got to bring our best ideas to the floor and be willing to compromise. So when we're talking about these middle grounds that you've suggested, how could you describe those middle grounds as being feasible choices that people can make, that they don't feel like they're abandoning industry or they're abandoning consumers? How can we present these middle grounds in a way that makes sense and is feasible for that proposed legislation? Anyone want to take that first? Jessica?
Yeah.
Well,
Yes. I'm gonna bounce this back on you.
Well, okay. It's funny. When Cam came out with his article last summer, I thought, oh, those are filled with great ideas, but I don't agree with all of it. Well, I reread it for purposes of this panel, and I think it's great. I'm going to validate you too, Cam. And I think there's just so much in there that's good. That the conflicts preemption, achieves the consistency, but doesn't wipe out everything that it doesn't need to wipe out, things that have coexisted for a long time. So I think that choice is good, and no savings for more protective state laws, I think was the right call for the reason I'm going to explain it in a minute, and the sunset allowing for revision. So I think the entire proposal is good, except for there's one aspect of it that I disagree with, and I'm gonna and that's because I think in order for everybody to embrace a solution, it has to be simple and it has to be feasible, and everyone needs to understand it. So my experience with GLB convinced me that so all of Cam's elements work except the one of giving the FTC or whatever agency the power to make preemption determinations. And so GLB's model, which I don't support here, and neither does Cam wholly, it's a conflicts preemption model, but it has a savings for greater protection. And it gives the FTC the task of making preemption determinations. And through my experience, I was at the FTC, the one supervising the preemption determinations that the states lob to us. And from my experience, greater protection is very complicated. First, you've got to do a line-by-line analysis to see whether there's a conflict. And then you have to do a line-by-line analysis to compare the level of protections, which ends up being very time-consuming, often very subjective. For example, opt-out, opt-in always seems more protective than opt-out. But what if it's for a different set of information? What if the opt-out is robust and prominent, but the opt-in is a click-through? So that's the kind of thing that's the greater protection standard. It's very hard to make that evaluation. You know, what if one law has opt-in for certain uses of data and the other law bans it? You know, those are value judgments you have to make. So I think the greater protection standard is overly complex and shouldn't be adopted. Asking a federal agency to make determinations about in the moment, like a state wants to pass a law and it presents its law to the FTC and says, can you give us a determination as to whether this law is preempted? That is just putting the federal agency in the same political quagmire we're in now. The states were sending us those requests and we didn't want to say, oh, your law is preempted. Often the states were giving us those requests in the context of heated litigation. So if you give the states that, if you create a preemption standard where a federal agency has to opine, you know, as to whether state law is preempted, I think it's a very difficult political spot for a federal agency to be in. And I think we ought to resolve that, a court ought to resolve that later.
That sounds great. And Cam, I know you were called out and your article was called out on that, so I'm going to come back to you in just a sec. But first, I just wanted to check in with Stacy because the Future of Privacy Forum, you have done so much work there on this topic and you have some great resources online. And I just wanted to see if you also had any thoughts about that middle ground and what you think is likely to be successful and win friends on both sides of the aisle.
Sure. So just maybe to start with the question of having a federal agency make preemption decisions, Jessica, all of the points that you're making align with what I saw in the research in instances where sectoral laws already give the FTC the ability to make preemption decisions. So GLB, of course, was one of them, as you pointed out. The FTC also technically, I think, has that authority with CAN-SPAM, and HHS has that authority with HIPAA. And there are a couple of other examples. And in each of these cases, the FCC with the TCPA, in each of these cases, the federal agency either just declined to make those decisions for decades or more, and then they eventually went away or just never engaged with it. So it does seem like something agencies are unwilling to do.
All right, and Cam, do you have some thoughts on that?
So I agree with what Jessica had to say about the more protective standard. And that's not something that we recommended across the board, but something that would apply after a sunset, which Commissioner Wilson referred to. And in some sense, look, I mean, we were, part of our purpose was to sort of educate about a number of the options. So we really, I think, took a broad menu and had a little bit of this, a little bit of that to show ways that these could be crafted together. So one of those was, while establishing broad preemption of regulation, state regulation that's inconsistent with the federal law. That's a form of conflict preemption. And that's the model that I adopted from communications law. But adding to that a sunset after 8 years, a little bit of a sweetener, but still this option to come back and deal with more protective state laws in certain instances. just different ways of slicing it. I think that comes back to the point that I was making, that all of this is going to take some compromises. There are lots of different elements of that, and things that may get thrown in to help bring people aboard. But I think the fundamental part of the preemption debate is you can't have field preemption, and you need to allow for a broad spectrum of existing state laws. States have had a fabric of common law and statutory laws and constitutional provisions in a lot of states that have developed over 130 years since Warren and Brandeis wrote their right to privacy article. So there's layers of state law, and you can't just erase all of that. So you need to do a little bit of a jigsaw puzzle.
Well, so that's going to take me out of order, the order that I promised you a little bit, but that leads very nicely to a question that I did want to ask Stacy, which is, can you talk a little bit about the risks of preempting too broadly? So what are the effects of preemption on the need for, you mentioned earlier, localized state action? Like, what is something that's very specific to local areas that we could really compromise by having preemption that's too broad?
It's a great question, and I think briefly before I get there, I'll just add 2 more points to this sort of core question you're raising around ways to compromise. The first is, I'm not necessarily convinced on sunset provisions, even though I think it's interesting and may in fact be a useful way that we do reach compromise, only because I think there might be a risk in disconnecting the substance of a federal privacy law from the preemption decision in time and space, because those 2 issues are so interconnected, including with this question of state laws, right? There could be a risk there. I'm not totally sure on it. And the second is that there may be compromise in different pieces or substantive provisions of a federal privacy law, right? So we don't necessarily need to think of federal preemption as one thing that applies to the whole privacy law in all of its parts and aspects. It might be that preemption is appropriate for some things, like having a single federal standard for consumer data access requests, right? And less appropriate for other things. And for that, I think we can look to the specific business activities, maybe look to the specific nature of the data and the ability to localize different compliance requirements. But I'll just sort of throw that out there into the compromise question. And then into what you asked about the risk of preempting too broadly. There are plenty, and our friends in the consumer advocacy space have raised them very compellingly, I think. The first one is the effect on existing laws. So we tend to focus very narrowly on what do we do about the California Consumer Privacy Act or the Virginia law or the Colorado law, right? Because these are omnibus new privacy laws. But we in fact have hundreds of state privacy laws that go back many, many, many years that that are in place that people don't necessarily want to see wiped out, that govern things like existing sectors that are not preempted by federal law, right? Like we talked about, but also around sort of these narrow, discrete areas of law, like digital assets of decedents, like library records laws, state surveillance laws. We have different state surveillance laws, of course, as we know, and there are all these areas, laws that prohibit your employer from requiring your social media password, right? So we have to understand the effect on this huge body of state privacy law. One way to do that is to incorporate lots of them, right, into the federal law, and then maybe we don't need to worry about it so much. But even if you sort of handle that or have them addressed through savings clauses, you still have a risk that, Jessica, you really raised very well, of ossification. We have to make sure that a federal privacy law is still as effective in 5 or 10 or 20 years from now as it is today. So it has to have the ability to evolve. And a big part of that is specific but robust FTC rulemaking authority. And the best example of that, I think, is the Children's Online Privacy Protection Act. COPPA is highly preemptive. When it was passed in 1998, it applied to what we think of as traditional personal information, names, email addresses, information collected through online web forms directly from children. And because FTC rulemaking is a feature of COPPA, the FTC revisited this in 2013 and issued rules that clarified that because of the evolving nature of technology, personal information under COPPA would be considered to include device identifiers, cookie IDs, other forms of online identifiers that are sort of core to how we understand online and mobile tracking of children. If that option hadn't been available, then we would have had a real problem because the federal law would have preempted state efforts to keep pace with evolving technology. So that's a really huge part of it. I'll stop there. Well, so there's evolving law. The other way to address that, I think, is through the common law, right? So you get into the remedies question and the question of a private right of action and courts being able to evolve these things over time. That's a big piece of it. And then, of course, there are going to be new technologies in 20, 30 years that we're not anticipating, that we're not imagining right now. We'll be talking about virtual reality and augmented reality and brain-machine interfaces and things like that. So the law has to be able to keep pace with the times.
And so the COPPA is a great example, and talking about that rulemaking as offering a degree of nimbleness and allow a response to changing circumstances as opposed to the ossification. And I have to say that I think there's been some suggestion that that kind of rulemaking would be advantageous over the Magnuson-Moss kind of unwieldy rulemaking that the FTC is saddled with at the moment in the context of unfair and deceptive practices. So that brings a lot of great ideas into those benefits. And we've talked about these various and numerous state laws on privacy, but a lot of them have been piecemeal, some in health, some with student data, some with the local surveillance, some with the libraries. But now more recently, we've gotten these 3 laws. We've gotten California, we've gotten Virginia, we've gotten Colorado attempting to fill this gap. And so how, Jessica, maybe you could take this one, like how do the passage of those laws affect this debate on preemption in your opinion?
Well, I think there's a few lessons from those laws. There's probably a lot of lessons from those laws. And by the way, I did the first COPPA rulemaking, so I like the reference to COPPA. So as to the state laws, on the one hand, the laws are pretty consistent. You know, the sky didn't fall because there weren't, you know, this torrent of conflicting laws. Now, there were certainly costs of having multiple laws, but it didn't turn out to be the disaster everybody predicted, although many proposals in the states have been different. So there's no reason to believe that's just going to continue. On the other hand, my second observation is the state's laws so far aren't all that strong from a consumer perspective. The focus is mostly on blocking third-party sharing. There's lots of exceptions. Oh my God, particularly Virginia. I mean, there's so many exceptions that swallow the whole. And only California contains a private right of action, and it's a narrow one. I mean, it's significant, but it's not as to the entire statute. So that suggests that a federal preemptive law, if done right and have with strong protections, could yield a better outcome than the states, even if it preempts the states. Stronger protections while also providing the greater consistency that companies need for compliance and that consumers need to know what their rights are throughout the whole country. But I think a third lesson of these laws is that since they're not that strong and they're not so different from each other, they haven't created the pressure on Congress to act and show the leadership it needs to provide at the federal level that some were hoping. So many of us who do support a federal law and have lamented that Congress hasn't passed one, thought, well, once the state starts passing their laws and there's chaos everywhere, the feds will think they have to act, and that hasn't happened. But so I think in order for that to happen, we're going to need much more aggressive and disparate state laws to create the panic that is necessary.
Cam, do you have thoughts on that?
I'm sorry, I was just looking at the chat. So let me, pick up. I mean, I think, the states really set, in some sense, a predicate for the federal debate. I share Jessica's sort of frustration that Congress has not been as responsive. But I do think that there's an opportunity here to do better than the states. And I think that's really a big part of the political equation on preemption. The consumer advocates, privacy advocates, civil rights groups have advocated for private right of action. You're going to talk about that shortly. That's one of the pieces of the trade-off. I think, as Christine Wilson said, that we need to think more broadly, not just about private rights of action, but about redress and what are the avenues that a law provides for redress. But clearly, I think there needs to be protection for some core privacy interests, and I think that's where there's an opportunity for federal law to be stronger, to provide for some kind of private right of action, to deal with civil rights, to deal with boundaries on collection, use, and sharing of data, which is something that the state laws don't do. And I think if you do those things, there you get to the sort of win-win that I'm talking about, because you would have a federal law that is stronger in some important privacy protections, stronger in redress than Colorado or Virginia or California. And at the same time provides a strong federal standard that really substantially preempts a lot of state activity in this area.
And
that's good for consumers to have a consistent law, and it's good for business.
And do either of you, also Jessica or Stacy, have any thoughts on this point that Cam is raising about the integral relationship? And we're going to be moving to the private rights of action and remedies in the next panel. But do you have any other thoughts on how these two topics are inextricably intertwined? It's almost hard to talk about one without talking about the other. Anything that you wanted to add on that topic?
Sure, I'll add as well. So there's of course the big picture political question in which these two things are seen as major sticking points, and with people having very different views, making them a potential area of compromise makes some sense, right? But in a legal sense, I would say there's also a very kind of tricky, complex interrelationship between remedies and liability and preemption, because when you talk about federal preemption of state laws, you're not only talking about preemption of state statutes, but if you write a preemption provision too broadly, you're really talking about law, big picture, common law, tort liability, contract law. Someone in the Q&A raised the question of municipal laws. Yes, those two, right? Guidance and frameworks in their application, right? So all of these areas of law are included in what could theoretically be preempted by a federal law. And so, you have to think carefully about what effect a federal law is going to have on the ability to bring a state tort or contract claim, or a negligence claim, for example, for a similar violation. And a lot of that is outside of the world of privacy, I'll just add too. So there's a real risk in doing this wrong, that we eliminate civil liability claims for things like civil rights violations. Civil rights organizations have raised, for example, that states have very different public accommodations laws and state civil rights laws. And all of those are inextricably bound up with the use of data and personal information. So we're going to affect those either deliberately or inadvertently. So we should be thoughtful and careful about how we do it.
And just
add that. Oh, did you want to go to the next question?
No.
Oh, okay. I would add that, you know, we've talked big picture about how we want a federal law that's as strong or stronger than state laws. And in this case, I think stronger, because I don't see the state laws as that strong. And I see the strength of the remedies as one element of that. It should be stronger in a lot of ways, including the remedies. And then the other thing that I would add is that I think as this debate goes on, the businesses focus on consistency, and others too, and the advocates focus on strength in terms of, and I think that having a preemptive law, not totally preemptive, these middle grounds, but that has very strong remedies, kind of achieves the consistency and the strength together, and kind of puts together the two goals that seem to be competing.
Okay, great. And so let me ask you also, since the students have done this research and we're putting together this web page that we hope people will use to draw ideas from existing laws, is there anything else? We've talked a little about GLB, we've talked about the floor of HIPAA with states being able to do more protective laws, a little bit on COPPA with the nimbleness of the rule. Are there any other examples from currently existing law that you would like to see people pay attention to? Anything that we haven't discussed yet that you think provides a good example of what we should be looking at in the preemption space?
Well, I'm not sure this is necessarily a good example, but something that you pointed out to me was that, because that COPPA empowers the states to enforce the federal law, which is really an important part of any preemptive model, regardless of whether it's totally preemptive or conflicts. States should be able to enforce, but that COPPA doesn't give the states the ability to get civil penalties. It just has injunctive and remedial and redress remedies. And so I think in any compromise, it would be very important that the states have full ability to enforce in the same way that the FTC can. Obviously, though, there has to be coordination between them. You don't want them falling all over each other. There's notification processes in COPPA that work pretty well. The feds don't stop the states from bringing their actions.
Right.
But the states should have full authority to enforce.
Great point, great point. Okay, well, we are to the last 1 minute of our part of this conversation before we have to pass it off to the remedies panel. Does anyone want to have a final statement?
I just want to say thank you. This has been, it's always a pleasure to talk with Jessica and Stacy, and it's been a great, terrific conversation.
Great. Well, thank you all so much for joining us. I can't tell you how much we appreciate your expertise. And I hope you'll stick around and listen to the remedies panel and the questions, and I'll turn it back over to you, David.
And thank you so much, Professor Dellinger. That was a fantastic panel. I don't think I've heard in 20 years a good discussion of the different aspects of preemption. So we'll go quickly into remedies so that we leave some time for questions. And one of our other student researchers, Lizzie, are you there to introduce the panel?
Yes, hello. Robin Spector has been an attorney at the FTC for over 20 years. She is currently serving as an attorney advisor to Commissioner Wilson advising the Commissioner on consumer protection issues. She has been particularly active in assisting the Commissioner in her review of privacy and data security matters, as well as conducting research and drafting speeches and articles in this area.
Thank you for that introduction, Lizzie, and your work in our office this summer. We have 4 panelists for this discussion on remedies and private right of action. Their full bios are on the Duke website announced earlier. Chris Hoofnagel is a professor of law in residence at the University of California, Berkeley, where he teaches cybersecurity, programming for lawyers, and torts. Margot Kaminsky is an associate professor at the University of Colorado Law School and director of the Privacy Initiative at Silicon Flatirons. She specializes in the law of new technologies, focusing on information governance, privacy, and freedom of expression. Francella Ochillo is the executive director of Next Century Cities, a nonprofit that focuses on expanding high-speed broadband connectivity across the US. She is an attorney and digital rights advocate whose work underscores how widespread broadband adoption can improve educational outcomes, economic mobility, the ability to age in place, and pathways for participating in our democracy. Rory Van Loo is a law professor at Boston University whose research focuses on the intersection of business, technology, and regulation. In the months leading up to this event, David and I had many conversations with these panelists, and our analysis of the question of whether to include a private right of action in federal privacy legislation led us to asking a broader set of questions, as Commissioner Wilson alluded to earlier. What is the goal of a private right of action? What remedies are we hoping a private right of action will provide for individuals? And what deterrent effect will it have for industry? Chris, you recently published an article discussing these issues, noting that the need to identify a policy goal is important. Can you elaborate on this? And in addition, your article included a matrix with questions for regulators to map the remedies landscape for privacy that I think would be useful to describe.
I'm happy to do so. And first, let me thank you, Bobby, for putting this together, and David Hoffman and his student team at Duke. This has really been an excellent program, so thank you for having me. Let me start with the context of our report. It was developed with Jim Dempsey, Ira Rubenstein, and Kathy Strandberg. And what our team did was we held workshops with experts outside privacy law to learn about remedies that aren't in privacy statutes. I'll discuss that report, but today I'm just speaking for myself. You raised the issue about policy goals, and I think this is one of the main things that we have to be thinking about carefully. We really should start these efforts by articulating our policy goals. The advantage of using policy goals is that it allows us to start surfacing latent and unexpressed goals, and we can judge them. We can also exclude them if they are adding unnecessary barnacles to a legislative vehicle. And I am suggesting in that there are some illegitimate latent goals in privacy debates. For one that will arise is the notion of litigation proofing an industry, but I don't think that's a legitimate interest. I'm a practicing lawyer, and I can see that there actually isn't a single industry viewpoint on privacy. And so as privacy competition arises, there actually will be private companies suing other companies over their privacy representations and misrepresentations. So it's not just about consumer class actions. It's also going to be about companies policing a competitive marketplace. And then finally, let me just introduce the deterrence framework quickly. I focus on cybersecurity at Berkeley, and I spend a lot of time thinking about deterrence theory. It's remarkably nuanced and very well developed since World War II. To deter, one needs a credible regulator and a commitment to enforcement. So we have to start with a Federal Trade Commission or another regulator that really has the resources to police the beat. And that's a tall order. The basics of deterrence are rather obvious. There's deterrence by punishment. That's what we mainly think about in the sense of fines. But there's other deterrence approaches. There's internalization of costs. that is causing the actor to absorb costs of their activities. And there are denial of benefits strategies that are very effective. These are strategies that rob the actor of the riches from their misbehavior. So denial of benefits is one of the least developed in the privacy frameworks. Most companies that use deception or unfairness to collect data or to gain market share are not required to delete that data or otherwise give up the gains they received from their deception. There's also a less well-known area of deterrence known as compellence. And this is the idea that one can sculpt incentives to encourage the industry to behave responsibly. A compellence strategy requires some type of positive action from industry at the threat of losing some goodie. So the most obvious compellence examples come from safe harbors. Safe harbors give us the opportunity to horse trade for the most important issues in privacy. So for instance, I'll just throw this out there. Why not contemplate a safe harbor that gives companies immunity from class action litigation if they agree to minimize data collection, or if they agree to delete personal data as soon as they technically can after completing a transaction? Wouldn't a very strong pro-privacy commitment like that be worth horse trading for class actions? I think we should think about that. Compellence can also come from third-party gatekeepers, and an obvious example are payment companies, but I'll give some more examples later. And let me just conclude with two other features from deterrence that are very useful. One is that deterrence frameworks can anticipate guile. And that is something that has happened a lot in this field. Information companies are very good at saying, oh, we're not invading your privacy, but look at the fine print. And the second is over-deterrence. We don't want to over-deter. We want innovation. We want new services. So deterrence theory lets us think about that problem as well as an issue that we need to keep our eyes on. We need to protect privacy, but we also have to protect our economy.
Thank you, Chris. Margot, when we have spoken, you have discussed how privacy legislation typically includes a provision of individual rights in the bill and may also include a private right of action as one of the remedies for enforcing those rights, but that these rights could also be enforced through other remedies. Can you describe that interrelationship between individual rights and remedies and alternative enforcement mechanisms?
Sure. So I'm going to leave a large part of the discussion of alternative enforcement mechanisms to our fellow panelist, Rory Van Loo, who is an expert in this area. I did want to talk a little bit at first about distinguishing between individual rights in the privacy space and certain types of remedies. And this leads me to a similarly theoretical discussion of why we have individual rights in privacy to begin with. So if you look at the GDPR as an example of privacy regulation, the first half of the GDPR is a series of rights that are afforded to the data subject. And those include the Fair Information Practice Principles, such as access rights, notice rights, correction rights, rights of erasure, and so on, and including certain individual rights around automated decision-making. Then the second half of the GDPR is all about company obligations. And that often leads people to characterize this as being a two-prong approach where on the one hand, you have individual rights, and on the other hand, you have compliance obligations for a company. In some of our discussions prior to this panel, we talked about how individual rights can also be understood as obligations on companies. So an individual right of to notification is simultaneously a right of an individual to notice and an obligation on a company to furnish that notice in particular ways. So the question about why data privacy law takes this two-prong approach really goes to why we care about individuals at all. And I know it's been very popular recently to criticize leaning heavily on individual rights, especially in the US, where we've had this heavily critiqued notice and choice model. Individuals don't always have access to justice. Individuals don't necessarily have the bandwidth to make these choices or to invoke these rights. All of those criticisms are perfectly valid. And I also think those are not the sorts of things that should cause us to wholesale throw out individual rights. And when you look to the origins of these rights, to the 1973 Hugh Report in the United States, not a European regulation, you see that it's really about affording individual autonomy and respecting individual dignity in the face of statistically based decision-making. So despite the very valid operational criticisms about individual rights, at least theoretically, they really are core to a privacy protection system. And we see them popping up in places in state laws, including the CCPA, the CIPRA, the Colorado law in my home state, and the Virginia law. Now, how these individual rights should be enforced is a different question. So I think this brings me in direct conversation with Chris, really thinking about whether a deterrence theory of privacy regulation gets to why we have these individual rights to begin with. So on the one hand, you could frame the conversation about remedies as being about making sure corporations don't do bad things and making sure corporations meet their obligations. And all of that, I think, is a very valid framing. On the other hand, there's another theory about why we have private rights of action. It comes out of tort law, and that is the civil recourse theory. And that's really about giving individuals voice. So to the extent that we believe that individual rights in privacy regulation is about autonomy and dignity, there's a real question of whether that autonomy and dignity can be effectuated through a system of remedies that goes to deterrence and doesn't go to civil recourse. So my last example of this, where this sort of paradox arises, is when you look at the Colorado laws, with all due respect to my lawmakers in my home state, you see that the Colorado privacy law has these individual rights, but situates it in a sort of self-regulatory system where companies get to say no. They get to say, no, you don't get these rights. And then at the end of a process that is sort of a timeline laid out in the law, the company basically at the end of the process just says, oh, and by the way, if we said no and you have a problem with it, go see the state AG's office. That seems to me to be the worst of all options, because you are affording these rights in the name of autonomy and dignity, not allowing civil recourse, and actually distancing the enforcement mechanism from anything that would really provide a significant deterrence. So that ties back into the conversation from the earlier panel of how, the enactment of these state laws really changes the conversation around having a federal privacy law. The last thing I'd say is that, again, going to the criticisms of both individual rights and the private right of action, there's a lot of criticism of individual rights and private right of action, but not a lot of cohesive discussion of what the potential hurdles are in the regulatory context. So first, if you forego a private right of action, you lose the possibility of a self-interested actor acting in their own self-interest with motivation that matters to them. Second, you face issues about regulatory capacity with the agency. Third, you face issues of regulatory discretion. And fourth, the thing I think gets left out of the conversation the most often is that to the extent that we choose to regulate privacy by delegating a lot of decisions into private companies, having an individual right of action or some sort of individual recourse actually provides oversight potentially over the system of governance itself. So if we don't have a private right of action, we need to figure out how we can move to create similar forms of accountability in lieu of that particular form of recourse.
Great, thank you so much, Margot. And so I want to pick up on, you gave us a ton of material, but I want to pick up on part of what you were talking about on individual rights and go to Francella, because the individual access to justice point, I think, is something you can speak to in your work with marginalized communities. You've noted that disadvantaged populations often have the least privacy protections and rarely have the ability to weigh in on remedies for harms. And so do you believe that a private right of action is a necessary remedy to provide access to justice for these populations, or are there alternative remedies that could meet some of these goals?
Well, first I want to say thank you so much to not only all the people who put together this conversation, but especially the students who showed up, because I always want to make sure that I'm grounding it in a way that I needed to hear it when I was in law school, and to really understand, why does this matter? And so sometimes when I'm trying to explain what it is, I want to give you an example. So a few years ago, I was applying for a mortgage, and I did not have a choice to disclose that I'm African American. And there was actually a really interesting article that was released later that actually proved what I knew to be true. But I was actually offered what I knew to be higher rates. Some of my friends who had similar incomes actually were approved as single people. They didn't have the same resources. I actually had savings. All of these things were in my favor, and I had outstanding credit. And I was still told, you're a high risk, we're not sure, please, we need more time to review your application, and we'll need to talk to the underwriter. So a few weeks ago, I was actually reading this story that came out of the Associated Press, and it was a story called The Secret Bias Hidden in Mortgage Algorithms. And it was an African-American couple. They attempted to buy a $375,000 house in Charlotte, North Carolina. Both of them made six-figure salaries. Both of them had over 700 credit scores. And when they applied, they were actually, after they put down the deposit, they were told, we can't approve your mortgage. And one of the things that was really interesting that Associated Press did was they ran these statistics, the statistical analysis. They went over 17 factors of these mortgages across the country. And they said that 80% of lenders were likely to deny Black, Latino, or Asian Pacific Islander applicants with the same credentials as their white counterparts. Now, this is an AI and a privacy issue. As we're thinking about it, the reason why, obviously, when we're thinking about when these numbers are crunched and they're actually put into these large packages, people say, whoa, it's too hard to disaggregate the data. You shouldn't have an individual right. It's just a harm to this group of people that if they were really interested, they should figure out a way to get remedies. And the reality is, usually the people who have the most disparate harms are the people with the least amount of resources, also often the communities that have the least amount of digital literacy, and very often also the communities that even if they were to go to an agency, for example, the FTC, as a reactionary agency, they'd probably have to get together with 10,000 of their friends to get any sort of answers. And so when we think about what kind of remedies do we need to put in place to protect those individuals, we have to ask really hard questions. When we look at the past 2 years, there are millions of Americans who have received an email address for the first time. And I want to make sure that just sits in with people, just to make people uncomfortable, that if you are new to the digital ecosystem, are you okay with companies harvesting their data, collecting information that they might not know how to opt out? If you're comfortable with that, okay, sure. You're probably not the person who has to worry about, how do I use my privacy settings? Do I have rights if I'm a victim of fraud? Who do I call? You have options. But very often the millions of the people who are most disparately impacted are the people who don't have options. They don't have resources. They are not invited to these policy discussions, and they don't have lobbyists. So I always want to make it really plain for people. You might not have to worry about checking a box when you're applying for a mortgage, but I know that as someone with a great income and outstanding credit, it didn't make any sense that I was denied, but I had no recourse. What was I going to do? And I think that very often communities that are the most underrepresented, and I do want to point out, when I think people hear me talk about it, they think, oh, she's talking about African-American communities. Actually, the thing that the most disenfranchised communities have in common across the country is low income. And I remind people of that because if you are an Amazon worker making $20,000 a year, you are still within $10,000 of the poverty line if you work 40 hours a week. So this is people you know, these are your neighbors, these are the people you went to high school with maybe, they're in your hometown. And so I always want to make sure we're thinking about, do those people have rights when you go home? And so when we think about it, very often, the most thoughtful federal policy always goes to the connected. We agonize over whether or not people who are connected have rights, and do they have remedies, and do they have someone to call? But we aren't always thinking about how these ideas actually, when they are distilled and actually implemented in people's households or their communities, how does that affect the communities in the margins, the populations that don't have agency in these lofty conversations? How does that affect their rights? And so those are the questions that I always want us to get into a place where we're almost uncomfortable with it, because so much of this conversation is not just about how do we set up a framework that protects rights, but it's about asking questions about the power dynamics that got us here in the first place.
Thank you so much, Pantella. We know that privacy legislation likely wouldn't have a private right of action as the sole remedy. There will be enforcement by a federal agency, potentially state attorneys generals, and there could be other types of monitoring. So in thinking about these challenges that you cite, Pantella, about giving people access and creating rights, Rory, you've written extensively on other types of like supervisory authority, private monitoring, third-party monitoring. Can you describe for us some of the existing and potential regulatory systems that you believe could play a role in federal privacy legislation?
Yes, and one thing I just want to emphasize here at the outset is that because the FTC is the main privacy regulator, the privacy community tends to view regulation through the FTC's institutional design, which relies extensively on enforcement lawyers. I'm a lawyer, I don't have anything against enforcement lawyers, but there's a fundamentally different paradigm out there that's actually more common, and that's relying heavily on non-lawyers who monitor businesses. So 10 years ago, when I was asked to join the team that set up the Consumer Financial Protection Bureau, I was far more excited about the enforcement lawyers than that other group. And many people, myself included, kind of thought that maybe going into this, the best design for the CFPB was to do what the FTC does and to adopt that model. But instead, we opted for a hybrid approach. We had a big group of enforcement lawyers, but we also created a big group of examiners who are mostly not lawyers and who every day are collecting information from inside financial institutions, often on site or remotely sometimes, but regardless of whether anybody has done anything wrong. And that's a key point. You know, they get to see what's going on behind closed doors in these institutions. And these examiners can also independently police misconduct, but in a less antagonistic way than, say, an enforcement lawsuit would do, and have a more kind of collaborative approach almost to seamlessly improve and fix problems. And that model is closer to what most large regulators adopt. So the Environmental Protection Bureau, Environmental Protection Agency, for example, it has a large group of inspectors who are typically engineers, and they continually inspect these various firms, and they don't need to have suspicion of wrongdoing in order to get that non-public information. And this is important because you have to be able to detect wrongdoing, right? And it's hard to do that from the outside. And I can imagine a world in which the FTC gets a large group of privacy examiners to keep tabs more regularly on what businesses, at least in some industries, are doing with our data. And of course, to do this, the FTC would need more resources. So this is one way to potentially spend some of that $1 billion of additional funding that we heard about earlier that's being proposed. So if that funding never comes, or as a complement maybe, there are a number of other ways to kind of implement a private monitoring system. The more familiar model referred to by Chris earlier is referred to as gatekeepers, in which the law mandates, a private inspection company or a third-party lawyer maybe, or an accountant or something like that, whose sign-off is necessary for the business to operate. There's a newer gatekeeper model that is far less familiar to most people, in which the regulator or the law kind of pushes a core business to monitor other businesses it interacts with. So the CFPB requires banks, all the largest banks, to enforce consumer protection laws against all their third parties that they form contracts with, like call centers and mortgage brokers. These banks are expected to monitor those third parties for any kinds of consumer protection violations, including privacy. The FTC also did something like this in its settlement order with Facebook, requiring Facebook to essentially go in and monitor app developers for privacy violations. A final version of private monitoring comes not from the law forcing anyone to do anything, but from laws that simply empower helpful digital intermediaries. And my favorite example of this is an Israeli law from 2015 that required stores to release their price and product information in machine readable forms. These are stores that sell, everything from groceries to household items. And that law enabled entrepreneurs to launch online price comparison tools that many shoppers then used to decide where to buy. And within a few years, scholars concluded that that legislation had reduced retail prices by 4 to 5%. And we can imagine a number of laws that might provide related incentives for privacy digital intermediaries. Now, even with a Supreme Court that was enthusiastic about private rights of action, some of these approaches, I think, still would be appealing because they're possibly more efficient and more effective at deception detection. And I say deception detection because there's always going to be efforts to kind of conceal what's going on, and there's also just innocent kind of preferences to keep information non-public. And we can't monitor all these companies on our own to figure out with whom they're sharing our data and what they're using that data for. So any comprehensive privacy legislation should really closely weigh how to optimally deploy these various public and private options for oversight.
Thank you, Roy. So as you're talking, it sounds like we're talking about having a privacy law that has a combination of layered remedies for enforcement. And I know, Chris, your work has touched on the effectiveness of the TCPA and the FCRA, which do have a combination of remedies within those statutes for enforcement. So can you describe these frameworks and their effectiveness? And I want to just tell the listeners here that these are statutes that, at least FCRA is featured on the Duke website, and TCPA as well.
Thanks, I'd be delighted to. And so to hang more meat on the deterrence framework, it's instructive to examine telemarketing regulation, which has intricate and redundant features to create deterrence and compellence. Telemarketing makes it clear that no one compliance mechanism is enough. Even if you want to meet a very simple policy goal, one needs different tools to address different types of problems and different types of actors. And of course, in the TCPA, there's deterrence through fines and punishment. So individuals can sue as well. And in fact, interestingly, individuals can even sue in their small claims court if their state allows it, and most do. In some states, telemarketers have to post a bond before they start their calling activities, which is really interesting. In deterrence terms, this would be called holding an asset at risk. And the idea is that if you have an asset that the enforcer can very quickly seize, and pulling that enforcement trigger can be more consequential. Turning to privacy, I think we should be thinking about holding data and users at risk. That is, taking away data that are gathered deceptively or forcing the loss of users who are gained through guile. There's precedent for doing this. For instance, in a Federal Trade Commission case called Synthesia Marketing, the Federal Trade Commission required the company to reconsent their consumer base because it had acquired those consumers using fraudulent sales tactics. Turning to safe harbors, in telemarketing, safe harbors are very highly valued. But what's interesting about the safe harbors in telemarketing is that they do the work of the enforcer. Basically, to get that safe harbor, you have to do lots of paperwork that shows that your calling practices are legal and responsible. So that the paperwork itself helps the enforcer make the case. Let me mention 3 other dynamics here in telemarketing that we could think about in privacy more generally. Following on Rory, in telemarketing, there's some very interesting gatekeepers. These are generally service providers, companies like Twilio that control the SMS gateways. So this is how companies send SMS messages. And so companies like Twilio, actually, they boot their own customers off the network for misbehavior. So they perform a policing role. And this first point is related to my second. Gatekeepers like Twilio do boot bad actors because those gatekeepers themselves hold some third-party advertiser risk. That is, if the gatekeeper knows that it is helping illegal telemarketing, if it knows about illegal telemarketing or is assisting, the gatekeeper itself can be liable. So there's a natural incentive there to self-police. Turning to privacy, there is precedent in FTC cases to do third-party privacy liability. The FTC, for instance, could pursue third-party service providers who violate the privacy expectations of users of first-party services. That's very confusing, but if you want to see an example of a case, you can look at one called Vision One Properties, a 2005 case at the Federal Trade Commission. Finally, telemarketing regulation anticipates guile, and it has several mechanisms to address it. For one, the burden to prove consent is imposed on the telemarketer instead of the consumer. There's historical reasons for this, but there's also an economic reason. It's easier for the caller to manage such records than for all of us as consumers to manage evidence of consent. So we could, in privacy land, we could allocate some of these proof of fact issues to data collectors rather than to the user. And if I could just riff on one other thing to connect Rory's comments to Francella's, very important note about how we regulate. We regulate through the lens of the Federal Trade Commission, and we regulate through the lens as lawyers. And only lawyers would come up with notice and choice, because average people don't read notices, but only lawyers would say, let's have this system where people read 2,000 word long essays. I call this consumer protection solipsism. And we should start to recognize that we actually are regulating for the reasonable consumer. When we think about that, we're actually looking at ourselves in the mirror. We're not looking at average consumers or the consumers who actually need help. And the consumers who need help are not reasonable consumers. They're the people who, for various reasons, cannot act reasonably in the circumstances.
Thank you, Chris. So in terms of helping consumers, I don't think we agreed we can't leave this discussion without talking about the Supreme Court decision in TransUnion, which I think one would say didn't help those consumers who were listed as terrorists on their credit reports, and how that may have changed the landscape for privacy industry. So Margot, I know you wanted to address this point.
Thank you, Robin. So yes, TransUnion, for those of you who haven't read it, is the recent Supreme Court opinion about standing and privacy law. And effectively, it's relevant to this conversation because if it's impossible to legislate a law so that there is standing to sue, then you cannot afford a private right of action. I think it changes the conversation really considerably. So TransUnion in a nutshell effectively says, and I welcome my fellow panelists to contest this, that if information sharing or use violates a privacy law, there is no standing to sue unless you can create a close analogy to a historic right of action. That's reading it pretty broadly. So narrowly, what it's saying is that even though TransUnion violated consumers' rights to having accurate information in their files under the Fair Credit Reporting Act, TransUnion couldn't be sued because consumers didn't have standing to challenge this because it wasn't closely analogous enough to the historic tort of defamation, which also requires not just saying something inaccurate, but actually spreading it and damaging somebody's reputation. So where does this leave legislators? Effectively, I think you have three routes post-TransUnion, none of which make me particularly happy. The first is to actually legislate so that the remedy is an injunction rather than damages. The court in TransUnion very specifically says, we're talking about this with respect to damages. We aren't deciding with respect to an injunction. I'm not particularly confident that something done with just an injunction as the remedy would actually still pass this court's standing analysis, but that's one possible loophole. The second possible loophole is to write a law just to acknowledge that information has to be shared in some way that causes a damage to an individual in order for them to have standing to sue. This, in my view, is disappointing because it's not consistent with what we've even seen historic state privacy torts do. I mean, intrusion upon seclusion is about a violation of a person's expectations of privacy in a private space or in their personal seclusion. It does not require further distribution of information. So maybe legislators could get clever and try to think about a way to modify the substance to look like intrusion as opposed to looking like, say, defamation or the false light tort. My concern about this option is that you're then changing the substance of the law. So changing the substance of the rights that are afforded in order to get a private right of action doesn't really seem like the best solution for the reasons I discussed earlier. Finally, you could just get really technical and have somebody do a ton of research into historic causes of action across all the states where courts recognize the right to sue, and make sure that you craft your law so that every one of these has a historic antecedent, and make sure, I think, as Cam Carey has recommended, that that is very much contained within one's legislative findings in the crafting of this law. Once more, that's not ideal because we want to have privacy laws in the future. We don't want to have privacy laws that are merely replications of laws that haven't worked in the past. And so that is the TransUnion paradox.
Thank you. So I think we want to come back to where they left it on the preemption panel, which is, is compromise possible here? We have, consumer groups who are saying there has to be a private right of action, and businesses are saying we can't have a private action because we're going to be buried in a flood of class action lawsuits. But does this panel think there's a way to, include a combination of remedies and maybe a limited private right of action to give that access to justice and create effective deterrence without opening the floodgates to litigation? And I'm going to go around to each of you, and we're in lightning round, maybe a minute apiece. And so I'll start with Chris.
Thanks so much. So I'm going to color outside the lines here and say that I actually don't think we're ready for federal privacy legislation yet. And the reason why I think this is that the most important people still don't think that privacy is a value, a legitimate interest that should receive legal protection. And when I say the most important people, I mean people like Larry Page. As long as the innovators see privacy as a historical accident and just as an impediment to them making money, they're not going to follow a law, even if you pass one. So I think we need a little more time to generate a consensus in industry and amongst people that privacy is a legitimate interest worth protecting with law. I think the best glimmers for this is actually Apple. Apple is introducing privacy as a real competitive marker in a real way, in a substantive way. It's not perfect. Not everyone's happy with it. But we need to see more companies engaging in that tussle. And then I think we will see a underlying value shift that will be a signal that we're ready to engage. Right now, and I'll just leave it at this, we're at the point where the tobacco company executives come up and say, cigarettes aren't addictive, they're not harmful. That's where we are in privacy land. Privacy is stupid, it's historical accident, it's just in the way of innovation. We gotta push through that before we have a law that people will actually follow.
Fascinating. Rory, your thoughts?
Yeah, this is a tough question, of course, but I think back to the CFPB here a bit. And if we were to, say, create a new bureau in the FTC or a new privacy data regulation agency, something like that, with a strong supervisory arm, as I was referring to earlier, with this big monitoring force, it could give something to everyone. And so, I mean, that model, the CFPB was created by Dodd-Frank, which didn't necessarily provide additional private rights of action, and yet very strong consumer advocates could get on board. So this is a bit my regulatory paradigm here, but I have to think that there might be, if designed right, a regulatory solution that could please both parties.
Margot?
So I don't have a concise answer for you. I think that I'm a big proponent of looking at the nitty-gritty details of regulatory design. I do think it's important, as we discussed in the lead up to this panel, to really be thinking about not just the connection between a general deterrence theory and remedies, but also what the different aspects of a privacy law are supposed to serve. So if you're going to afford individual rights and your theory is this is to respect individual autonomy, then how can you justify through that lens not having some sort of civil recourse? Now, this doesn't mean there's a private right of action for everything, but it does mean that we need to think seriously about the ways in which we afford individual participation to people who really do feel hurt by the system individually.
And last word, Francella.
Thanks. I was actually thinking through how I'm going to address these three things just in rapid succession. Number one, I want to highlight that it didn't come up today, that the people who are some of the times the most egregious offenders of violating people's privacy rights are not always private actors. The government has participated in that. And so I want to make sure that as we're talking about what type of privacy framework applies, when we're thinking about how does that apply to whether it's local, state, or federal governments, which have done things that are offensive and cause substantial harms to certain populations. Secondly, it's important to think about the fact that there are deceptive practices that are happening right now for communities that, again, don't have any recourse. And this privacy, this entire landscape, it is becoming more and more complicated as technology gets more and more advanced. My information is not even as valuable as the information about me. And so what are we doing to think about how that information is being harvested, collected, packaged, sold, traded? So we need to ask really hard questions about that. And I think the idea that we should wait until industry is ready for regulation is something that is so troubling, because the people who can afford to wait are the people who already have protections.
Well, thank you so much to all of the panelists for this fascinating discussion. I commend the audience to the research on the Duke website and want to thank all the students for that. And I now turn it over to David for the Q&A.
Great. Thank you so much, Bobby. And thank you for leading that panel and having that amazing discussion. I think we're starting to see that there are lots of different dials that can be turned, different things that people can bring to bear to bring about the results that we want. And so I'm hoping we can bring back in now all of the panelists, if we can spotlight everybody and the moderators. And in the meantime, I want to cue Mark Scelzo, one of our lead researchers, who has been sorting through the questions that have been submitted. Mark, do you have one you would like the panel to address first?
Thank you, Professor Hoffman. Yes, I think something that's come up in a couple of different people's remarks that we can maybe flesh out a little more. We got a good question here from Harrison about the reasonableness of the FTC as an enforcer. More specifically, would the FTC be positioned to enforce federal privacy law, or might it be necessary to create a new agency? There's been, I think it's Senator Gillibrand had a proposal around that, and Commissioner Wilson mentioned the kind of House proposal. So anyone's thoughts on that?
Yeah, maybe if we could, I'd love to start with Jessica on that. Jessica, can you take that first?
Yes, although I seem to have lost my picture, but my voice is here. Yes, I've given a lot of thought to the agency issue, and the chief problem that the FTC has had all these years is it hasn't had sufficient authority or resources. Enforcing the law under Section 5 has been a tremendously difficult thing. It's a look back. It doesn't provide rules for the whole marketplace. It doesn't have sufficient remedies. We've talked, it's insufficient on so many fronts. And the FTC has had at most 50 full-time people working on privacy. So nevertheless, the FTC, and I say we, because I was there, created this program that has really been one of the most influential privacy programs in the world, that has gotten hundreds of companies under order, the largest civil penalty by an order of magnitude worldwide, very strong orders that form the basis of a lot of the research I was hearing about today for, novel ideas about how to enforce privacy. So I think if you gave the FTC, you nourished the FTC and gave it what it needed to be a privacy enforcer, it would do an amazing job. But that has not happened to date.
Great, and my apologies to Commissioner Wilson. I think Commissioner Wilson, you were also looking to comment on that. So I was wondering if you would be willing to build on what Jessica said.
Yeah, and my apologies for stepping on Jessica. Her answer was actually more thorough, more comprehensive, and more elegant than the one that I was going to give. I would just note in response to some points made in the last panel about remedies that, in fact, yes, the Federal Trade Commission has authorized or compelled essentially disgorgement of both consumer data and algorithms and other company assets comprised of consumer data obtained wrongfully or through guile, as Chris was describing. And so the FTC has been at the cutting edge of this field. When I was chief of staff to Chairman Muris in the early 2000s, we brought seminal cases in privacy and data security using a law that was not designed for that purpose. We have built an amazing program. And I think the Federal Trade Commission, if in Jessica's words, adequately nourished, is going to do an amazing job in this field. And I will say something tonight that I've never said publicly, but I actually am inclined to agree with Rory that perhaps we do need essentially supervisory capability at the Federal Trade Commission, in addition to enforcement lawyers, so that we can adequately carry out the task.
I think we've got our headline moment there for all of my students who are writing blogs about this. I'll hope I'll see some talking about that. Mark, do we have another question we could go to next?
Yes, I'd like to move to a great question in the chat about, it was specifically for Mr. Carey about his suggestion to address algorithmic decision-making in privacy legislation. But I would like that to be a little more broad. I think Franchella made some good points related to this. And I think Margot maybe has some experience here as well.
Well, thanks. I mean, I think it's important to do that because that is an use of personal information in ways that can affect the interests of the people that information relates to. And I think that's really what privacy protection is about. What we've suggested does not go to the stage that the GDPR does of requiring a human to explain algorithmic decisions that have an impact on legal interests or other significant interests, but it would provide transparency upfront about algorithmic decision making, and access through access, the opportunity to get information about that decision. And including within privacy disclosures, information about the logic of algorithmic decision making, where it's applied, and the logic of the decision. That's not about notice and choice. It's about making companies disclose in detail privacy practices and their data use, not so that somebody can check a box, but so that the FTC enforcers or supervisors and journalists and privacy advocates have good information that they can use to police what companies are doing.
Can the pictureless person here just add something to what Tam has said, which is that I think legislation can go further than just discrimination in algorithms. there's all sorts of discrimination that has gone on in profiling. It isn't necessarily use of a complex algorithm. And we've seen legislative proposals that have not just been based on discrimination for algorithms, but discrimination based on, data profiling more broadly. And that's another area where, even though the FTC is not thought to be the agency that brings anti-discrimination lawsuits, it has used unfairness to address discriminatory practice, for example, by auto lenders, and it enforces the ECOA, Equal Credit Opportunity Act. So it has had quite a bit of experience with discrimination issues, and I think has a big appetite for more if given the authority.
Yeah, and if I could just jump back in momentarily, I think what Jessica said is important. I think it is important that privacy legislation, as I said during our panel discussion, address civil rights issues, address discrimination, address the discriminatory use of personal information. And I'm encouraged to see that the latest bill from Senator Roger Wicker, the Republican ranking member of the Commerce Committee, includes a provision that would make discrimination based on data in violation of civil rights laws, a violation of the privacy law. I think that's a step in the direction. And I think that's part of the equation, whether it's algorithmic discrimination or any other kind of discrimination in the use of personal information.
Let's go to another question.
Oh,
Do we have another one?
Yeah, I'd like to ask Sean's question here. I'll just read it. Historically, marginalized communities have not been able to rely upon the government actors to protect their rights. How does this inequality factor into the debate about a private right of action? If any panelists would like to take that.
I'd like to take a shot at that first. Priscilla?
Because I think that sometimes even the hesitation or the silence speaks volumes. They're not included. So, I mean, I think that a lot of the times they're not included in these conversations. Very often, they are not the people who are represented with public interest groups or lobbyists or any other invitation to even be a part of this conversation. Even sometimes things that might seem like great ideas in the ideation phase in some of these roundtables, I think that we're not always asking questions about, does it actually translate that way when something is codified into a regulation or a law? Like, what does it actually feel like when it actually is implemented? And I think that we need to really ask questions about when we're saying we want to have robust privacy regulations, it's like, or protections, for whom? And I think if we need to be able to finish that sentence, are we saying that it really is for everyone, or is it for the people who are already connected? And I think that if we're asking about it for the people who are still struggling with connectivity, have low digital literacy, don't have resources, then we have to make sure that whatever ideas about the policy, the framework that we come up with, it needs to accommodate them as well.
Could I just add one additional point, and I just want to pick up on something that Franchella said earlier. We did not focus so much on the government as a wrongdoer in this space, but that is the point that I was making in my opening remarks. Yes, we are concerned about consumer privacy, but when you have this essential, this gargantuan hoovering up of all sorts of consumer data by companies that then can be tapped into by the government, there are lots of civil liberties that get essentially eviscerated, including the Fourth Amendment. And to Francella's point, we are talking about the marginalized and the underrepresented in terms of fancy lawyers and available legal talent. And we saw this last year during the protests. We saw lots of facial recognition issues. We know that facial recognition doesn't work as well for communities of color. And so we have, I think, a disproportionate impact with respect to violation of civil liberties and evisceration of the Fourth Amendment that we really need to think seriously about as a compelling rationale to get federal privacy legislation across the finish line. And so I'm actually with Franchella. I believe privacy is a right. It is a value in and of itself, but I don't want to wait until everyone else recognizes that, that it is a right and a value in and of itself. I think we need federal privacy legislation now to protect consumer privacy, but also to stop the violation and the erosion of civil liberties that is happening at an ever increasing pace as technology becomes more and more ubiquitous.
Thank you for that. And I would also like to add just that, we are going to continue doing research in these areas. I think the question asks a really important point about whether a private right of action would be usable by a lot of those communities and whether it would realize its goals. You're talking about groups often that have historically not enjoyed having their rights protected through the judicial system. But that feels to me like an area where there could be more research. And I would hope that anyone who's out there who knows that if there has been research about whether private rights of action have been effective in different areas with different laws in protecting the rights of historically disenfranchised groups, and to put us in touch with that research so that we can put it on the website and/or that we can look into creating some topics for some further research here at Duke. I want to take one more question. And so, Mark, do you have one last question we can use to wrap everything up?
Yeah, high standard there. I think there's a really great question in here that talks about what does the panel think of something like the United Kingdom's super complaint system? And again, we think that, do they have thoughts on how this might bolster the agency of underrepresented communities?
And just for those who may not be familiar with the UK super complaint procedure, I think I at least think of it as some sort of a collective right action for a third party, like a consumer group, to be able to bring actions on the on the stead of individual citizens, like what we see a little bit in GDPR also. Anybody thoughts on the degree to which that's an effective remedy? Rory?
I think it's a great idea overall. The complaints are one source of information. I know the FTC is one of the leaders in kind of leveraging consumer complaints, but then to give a third party the opportunity to actually take on those lawsuits is a terrific idea. I mean, this idea also, this question speaks to the importance of pluralism, regulatory and enforcement pluralism, and ensuring that they're visible too is a big part of it, especially for marginalized communities.
Can I just comment that complaints have not traditionally been a good source of for finding cases in the privacy area. People don't know when their privacy has been violated. They don't know who did it. If they know their information somehow got out, they don't know, they can't trace it back. So a much better source has been technologists and third parties who have the sophistication to research on behalf of consumers and figure out where problems arose. But consumers themselves tend not to complain about privacy, not because they don't care about it, because they don't know who did it.
Yeah, and if I just comment briefly, I think there's value in things like the super complaint approach, or California, I think allows you to designate nonprofits to represent you, but that's we essentially have something a lot like that in the United States already. And I think GDPR, the collective redress, was something new, where they don't have a robust class action system in Europe, or anything like the active civil society that we have. So, well, I think that's one thing that can be additive in the menu of things to piece together here. I think it brings less to the table than it does in the UK or Europe.
Stacey, did you want to add anything to that?
I'll agree with that. I think we kind of have a similar mechanism similarly. There have been some proposals that spell it out, but no question that already in the United States, if we were to have a private right of action, there would be the ability of nonprofit organizations with affected members to bring cases on their behalf, even though it runs into sometimes tricky standing questions. But nice thing to have, not a replacement for a private right of action. So just totally support all of the points that that Franchella made, and the question raised in the chat around the importance of private rights of action.
Well, I want to thank all of you for participating and being willing to come and to talk about these issues. Where a bunch of questions we didn't get to, but we are going to collect all of them and think about whether there are opportunities in those for us to do further writing in this area. Please look at the website, provide us any feedback, see anything that you know of that should be added as a resource there. We're going to continue our work in this area and our overall work in what we call platform accountability, in how governments can hold companies and other entities that gather personal data to really demonstrate that they're behaving responsibly. So you'll be seeing a lot of work from us in those areas, and we really hope that you'll be able to join us for future events. Thank you all so very much. Thanks for coming.